Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences, Inc. I am Dr. Steve Wood, and today with me is Kellie Howard-Goudy. She is from Collins Einhorn Farrell. Kellie's here to talk to me about cases. As we know, few cases actually go to trial nowadays. A lot of them will end up either settling on the eve of trial or settling earlier on in the case. So we've talked a lot about the psychology of trial prep and taking cases to trial. But today I wanted to spend a little bit of time on talking about settlement negotiations. So like I said, Kellie's here with me to talk about that. Kellie, how are you?
I'm good. How are you doing?
I'm excellent. Thank you. Could you give the listeners a little bit of background about your area of expertise as it relates to the law?
Sure. So I've been practicing for 16 years. I am a litigator, specializing in civil litigation, defense claims. So we handle large loss claims on behalf of business entities and other sorts of insureds and self-insureds. Like you said earlier, probably there's been a lot of different numbers quoted, but somewhere north of 95% of all cases resolved by way of settlement. So if you are in litigation, if you are handling claims anywhere in this area, you have to be familiar with settlement negotiations. And it's something that you see literally every single day of the week. It's something that you have to consider from the minute a case lands on your desk to the second the case is closed. You have to be thinking about, what are ways to resolve this case?
I think that's a great segue. So for some of our listeners, I know that there are a lot of experienced litigators who listen to this podcast or watch this podcast, but I also know that there's some people who are less versed in areas of the law. So could you just start at the top and talk to us about, who's involved in a settlement negotiation, how is the process will play out?
Okay, so settlement is basically a way to resolve a case short of getting a finding by a fact finder, which would be a judge or a jury, given whatever the circumstances of your case were. And so a settlement negotiation or a settlement is something that's meant to head off that process. And the primary reason why people undertake settlement and settlement negotiations is generally for cost considerations. Even in cases where you might have a viable defense or the plaintiff might have a really, really good claim, everyone has to think about sort of a risk-benefit analysis. What am I putting into this case versus the likelihood that I will gain some financial benefit at the end of the day? Some of the most difficult cases to resolve are those in which clients come to you and say, it's the principle of the thing. I think all lawyers quake in terror when our clients say it's the principle of the thing, because all of us have found that principles are extremely expensive. Yeah. So that's kind of how settlement starts out. It's really a risk-benefit analysis that's engaged in by all parties to a matter. So there may be a plaintiff, a defendant. If there's a case involving insurance, then you may have a claims representative who's involved, as well as their insured, who may be your client, and a plaintiff who has a claim and their attorney is involved. All of those folks are involved in a settlement negotiation, and everyone has to decide at the very beginning, what are the risks, what are the benefits, what do I want to get out of this case right from the outset. So that's kind of the anatomy of a settlement, sort of at the outset, who's involved and how about it.
Yeah, and we had talked before about the principle, and some clients don't want to settle. Who usually initiates the settlement negotiation? Is it usually the plaintiff, the defense? I think I know the answer to this, but I'm curious to hear who usually initiates the settlement negotiation talks.
I would be curious to hear who you think it is. So I have not found, I can't say that there's a rule about who initiates it. I think I would say most often the plaintiff will ask if there's any interest in resolving the case. But who initiates it may not necessarily be who's interested in it or who's interested in it from the beginning. For strategic reasons, you may not hear defendants saying that early on. And, by the same token, some plaintiffs may not say it early on. But that doesn't mean that it's not something that defense attorneys and our clients aren't thinking about right from the outset of a case. Most defendants, especially when you represent large entities who are running business organizations anyway, are interested in their bottom line from the very beginning. They generally have an overarching sort of doctrine about the way that they deal with litigation. And that you should, if you're their lawyer, that going into a case, how does my client feel in general about resolving cases? Do they want to do it early on? Do they want to engage in a lot of discovery up front? I mean, that's something that the lawyer should know, so that when and if the plaintiff does approach you about settlement, you have a reasoned position based on your client's business goals and needs. I mean, that's something that should always be at the forefront of your mind. What's going to fit their business needs and what's going to fit the particular facts of this case.
Yeah, and it's funny that you said the plaintiff. That was kind of what my initial thought was that it was the plaintiff that was doing it. Although I will tease a little bit later. I think we're going to talk a little bit about this topic, but my thought was that plaintiff attorneys tend to want to get in and get out, right? Get a case, work it up just a little bit, and then try to go into settlement negotiations and get their money and get the heck out, versus having to really draw the thing out and expend a lot of money to actually work up a case, versus the defense who is willing to spend the time and the money to work up a case and get it prepared to go forward. But obviously both sides at some point are considering settlement negotiations. But
right.
You've talked before about all the different areas that you've done work in. Have you found any sort of area that or type of case that is a little bit more difficult to settle than others?
Yeah. So the type of case that you probably will see resolutions that come up very early on in a case are cases where there are not disputes about liability. So here's a perfect example, like kind of a low-level example, a dog bite case in the state of Michigan. Dog bite is what's called strict liability. Is it a dog? Did it bite somebody? Then someone has to pay for that. Unless, there was trespassing or there was an issue of provocation of the animal, then someone's paying for that. So when you come into that kind of a case, very early on, you already know. It's just a matter of what are the damages. Now that can get sticky. Sometimes it's like, okay, you have a paperclip size cut. So that's $1,000 or whatever little amount of money that we want to give you. And you say it's worth $100,000. And then, that's going to cause issues. But those are the kind of cases that you want to resolve because you're not disputing liability. And if you get in front of a fact finder, the issue that you did whatever is said of you, that's going to be established fact. So that's something you want to talk about. The most difficult kinds of cases to settle, conversely, are those that do involve liability disputes, where the client does not think that they are liable for whatever it is that you're saying they're liable for. Because if we're talking about psychology, then the psychological, even for a business entity, you may not think that businesses have psychology, but they do. And the psychology of anyone involved in a lawsuit who does not think that they are liable for whatever it is you're saying that they did can be very intransigent. They can stop viewing a settlement in terms of those business cost and benefit analysis and start to see it more as an admission of liability. Even though in our settlement papers, our settlement agreements, we say right up front, this is not an admission of liability. And psychologically, you feel like paying a bunch of money, it's like I'm saying that I did something wrong. So that can be very, very difficult when there are issues of liability. Those folks can dig in. They want to be vindicated and they don't want you to get a penny out of the case. And not that I necessarily blame them. And the same thing is true on the other side, on the plaintiff side. When plaintiffs feel like you have definitely wronged them in some way, whatever it is, then they may not want to take a settlement. They may want to have their rights vindicated in front of a fact finder. They want a third party to come in and say, you were wrong. This did happen. Even if the amount of money is lower, there's still some sort of psychological vindication from having someone outside of the case say that this is what happened. So those cases can become very sticky to negotiate by the attorneys who are involved, because you can sometimes be the only remaining people who are like, okay, listen, everyone has to come back and focus on what's important here. We're going to spend a lot of money, fighting over who's right and who's wrong when that may not be necessary.
Yeah, and I think that's a good point when you're talking about that. You and I were talking before we got on air here about witness training and stuff, and you could get a witness, especially on either side of the case, that's really wants to dig in and really wants to feel vindicated, that they go into their deposition and what becomes a normal deposition causes them to go off the rails because they're getting really defensive. They're really trying to dig in. They're really trying to win the case. And then that settlement offer either gets pulled or the number that was initially on the table now all of a sudden becomes a lot higher. And now your settlement negotiations become a lot stickier, and they become a lot more difficult to do. So that's another thing, like you said, from a psychological standpoint, if your people are really, really digging in, they got to be careful to not let that bleed over into the deposition and cause problems.
Yeah. What the psychology has to be is everyone has to understand what it means to win a case, right? And I mean, winning a case doesn't mean that you get a jury verdict in your favor. Winning a case doesn't mean that you pay nothing for the case. Everyone has to come in with a good sense of what it means to win a case. Winning a case might mean that I don't spend 2 years litigating this case and, $300,000 just to get a no cause verdict at the end of the day. I mean, that's great, but I'm out $300,000 in 2 years worth of litigation. Right. So that may not be a win. So I think, you watch law shows on TV and, winning is all about what happens in front of a jury. But in real life, that has very little to do with whether clients walk away feeling like they won a case. So I think that everyone has to keep that front of mind. It's the lawyer's job, really, to balance the client's right to vindication, whether you're on the defense or plaintiff side. You have to appreciate that your client has a right to be vindicated in their position with what a win looks like for them in that case. And you have to continuously remind the client, I know that you have your right to vindication, but this is what it looks like to win this case.
Yeah, it's another good segue. I think I think you should become a podcaster here. You've had 2 good segues going into the next topic. So we're going to talk now that we've kind of got all the background stuff out of the way. And now I wanted to talk to you more about, so we kind of get in a sense of we're going into settlement negotiations. What have you found is the beneficial approaches to take? What are some good approaches to take in settlement negotiations?
So one thing that I think you have to be building up your credibility in a case from the beginning, or maybe even, from the beginning of your career. Like, settlement negotiations take a lot of credibility by the people involved because there's some degree of trust that is being exchanged between the parties. So if I come into a settlement negotiation and I tell, let's say that we're settling the case and we're using a facilitator, which for those of you who don't know a lot about settlements can be undertaken as we call direct negotiations. So that's negotiations between the plaintiff's attorney and the defense attorney and the parties. We can directly negotiate with one another. Or sometimes we bring in what we call a neutral third party, and that's a facilitator or a mediator, and they will work with the parties to reach some sort of a resolution. So particularly if you're doing the second kind of negotiations using a facilitator or a mediator, your credibility as an attorney is paramount. So if you come into a settlement negotiation and you represent, I only have $5. So, facilitator, I need for you to get me this case for $3 because I only have $5. And if I spend all $5, my client's going to be mad because they're going to feel like I just ran, all their money out. And so the facilitator has to trust you. They have to think that you're telling the truth, that your client is straightforward, that you wouldn't lead them wrong. And at the same time, the other party has to have some degree of trust in what you're saying as well. And what I have found is that it was difficult to establish that at, back when I was younger and I was just starting out in this. And, I'm very well preserved, but I've been around for a long time. And so now I've seen a lot of the facilitators, I've seen a lot of the attorneys, we practice all in the same areas. And so you built up that credibility over a number of years. And that really does sort of grease the wheels of a settlement negotiation. Because if you have to spend a lot of time just proving to the other person, I'm not trying to rob you blind, I'm not trying to be a jerk. That takes up a lot of time. And time really is money in this industry. So you can wind up wasting a lot of money just trying to prove that you're a credible person. So that's one thing. The other thing is you need to have had really clear communication with your client. Your client needs to know what, if any, exposure they have in the case before you get to the point of negotiating a settlement. That is particularly true if you're going into a mediation or a facilitation. I had a mentor told me way back in the day, you never want to surprise your client with a settlement. If you've been telling your client all along, this case is worth $5, and you get to some point, way down in the case at a mediation or facilitation, you say, surprise, it's $500. Yeah. Nobody is going to be happy. You better have a very specific reason for doing that, or psychologically, the feeling might be that you flaked at the last minute, that you were scared, that you weren't able to take it all the way. But if you've been telling them all along, listen, this is what your exposure is. This is what I'm going to try to do. I'm going to try to get it for $5, but really between you and I, it's worth $500. Then that's a different story. They're not surprised, and that doesn't throw everyone off. So you don't want to surprise them. The other thing, and I had actually wrote some of these down, is that you want to be aware of the strengths and weaknesses of your case and of the other party's case. It's good to be confident. I had a property professor when I was in law school who said, the job of a young lawyer is just to fake it until they figure it out. That's good when you're young. But, once you start representing clients who have large amounts of money invested in their litigation, you better not be faking it anymore. You better know the strengths of your case, know the weaknesses of your case. That's part of being able to clearly communicate with your client. I say this all the time. You can serve the Kool-Aid, but do not drink it. Now, you are welcome to hand it out to other parties, but you cannot drink your own Kool-Aid. You cannot go into a settlement negotiation, high on your own supply. I like you that. Have got to go in there sober-minded, aware that, I'm saying this, but, truthfully, I know that, my guy was drunk when he was driving that truck. So, I know that, so those are kinds of things that you have to know. You have to be aware of the strengths and the weaknesses. And the last thing that I would say, and this is definitely a matter of psychology, you have to have a stone cold poker face, because at some point you might have to pull the plug, and you might be thinking to yourself, man, it's 200,000 and that's a really good number. But your client doesn't want to pay that much. Your client is like, no, I want it for 100. And you're like, that 200 is so good. At some point, it's the client's case, it's the client's money. You got to have the poker face. You got to be able to say, no, we're going to walk. If that's what it is, we're going to walk. We've made the evaluation. This is what we think it's worth. That's the end of the story. We're done. The day is over. And, I cannot tell you that I haven't left settlement negotiations or facilitations, with my armpits were sweaty and, I was like, oh my God, this is never going to work out. But that is part of how things are done. I mean, there is a point at which the client wants to pull the plug, and you have to have the fortitude to pull it. And then you got to be able to back that up later on as the case goes on. So those are the sort of strategic considerations I would say apply to any settlement negotiation.
I think you brought up a couple good points there that I wanted to touch on. The biggest thing being knowing what your case is going to be worth prior to going into settlement negotiations. And I think a lot of times when we talk with attorneys or we talk with clients, the thought is that we come in and do these mock trials and focus groups basically right before going up to trial. But a lot of stuff that we're seeing it more on the front end, right before settlement negotiations, because it allows the client to go in and it allows the attorneys to go in and know what the value of the case is. Worst thing is you don't want to go in, as you said, and say it's worth $5 and then find out later it's worth $500. You want to be able to go into that settlement negotiation having a clear vision. Like I said, the way we've been able to help clients is to do mock trials and focus groups on the front end rather than waiting all the way until it gets up to trial, because then it also puts you in a better position of strength going into settlement negotiations. Mm-hmm. I know I can think of at least one settlement negotiation where the information that was used from a focus group that we did was actually used in the settlement negotiations to help clean up the case and settle the case. So I think that was a good point where you're talking about knowing the value. The second one, and I love it, is you're serving the Kool-Aid versus drinking the Kool-Aid. I can't tell you how many times I have seen where, attorneys and clients just won't get out of their own way. And we will do mock trials and people will be having panic attacks, listening to juries talk about things, and they just can't get past the idea of what their thoughts are and what's beneficial to the case and what's impactful. And they can't believe that other people don't see it that way.
Yeah.
So I think that was great. I think I might steal that. Forward. I like it.
Yeah, one of my mentors told me a long time ago, he said, I thought I had this great case. It was a good case. And I was saying, we're going to go in there, we're going to stomp them, we're going to pulverize, whatever young lawyers say when they haven't lost the trial yet. And he said, listen, that guy on the other side of the table, we have in Michigan, we have P numbers, and the numbers, the lower the number is, the longer the person's been practicing law. He said, that guy's got like a 2-something P number. That means he's been around for a long time, been practicing law. He looks like he's done reasonably well. There's a reason for that. Don't forget that. Like, as good as you are, just think about it. There's somebody on the other side who, some of them are not good, but some of them are very good. And they've been around for long. You have to remember there's another perspective out there, and we can become sort of enshrined in our world, whether that's defense world or plaintiff world. And all you talk to are defendants, all you talk to are claims folks, all you talk to are business folks. Those folks all have a certain perspective, and it doesn't serve your client well if you never journey outside of that world and see what the psychology is like in the rest of the world. And so organizations like yours, Steve, actually do help us. Even we've done like mock trials within the firm sometimes, but even if you take a paralegal, if you take the people from the accounting department, we're all still defense folks. They're defense accounting folks, defense secretaries, we're all still defense folks. So we all have a certain orientation. You really have to find some way of getting outside of your world. And that's the value that I see in services like yours. It gives us a way outside of our echo chamber.
Yeah, excellent. I just want to wrap up with one more topic. With COVID, I know Michigan is higher on the scale right now as far as the number of COVID related cases and stuff. How do you think about kind of the future of settlement negotiations, whether or not cases are going to be settling more often? Have you seen that judges are pushing for settlement negotiations more than usual? Kind of what's the temperature gauge in Michigan right now as far as that goes?
Yeah, that's a good question. So judges have always sort of pushed for settlements. Judges are the people who've been in more trials than any of us. So they know what the risks are for all of the parties to get involved in a trial. They know how long they take, how costly they are. They're always kind of pushing us to resolve our cases if it's at all possible. And I have seen more of that just because it's difficult to get a trial date in some jurisdictions, or impossible to get a trial date in some jurisdictions because they're not convening juries, or, they're only convening one jury at a time, and there are, thousands of cases sitting on the docket. So under those circumstances, the judges have an interest in getting you to resolve the cases, and also the clients who are, sitting around. The defendants can't clear their books of whatever the claim is, and the plaintiffs don't get anything while their case is just sitting there and languishing. So I do think that there is a lot more emphasis on settlement right now, especially in the state of Michigan. I suspect it's going on in other places as well. One way that I can tell that that's the case is because, the facilitators that have the most sort of credibility in the community, it's like 6 months to get on their calendar. So you're like, okay, this is something definitely is going on here because you can't get in to see anyone. And there are more facilitators cropping up actually. So more people sort of dipping into that world and trying their hand at that. I think that will, settlements are something within an organization, they trend back and forth. Sometimes an organization will look at their legal expenditures and they will think to themselves, we're spending way too much money on litigation. Like, we need to start moving these cases along. And so you see a lot of settlements. And then, a new general counsel will come in and look at the books and say, we spent all this money on settlements. Like, we're not settling anymore. We need to show these people that we're going to stand up and fight. And then, nothing settles anymore. It just depends on and I can think of one large organization that definitely happened with, that was known to be intransigent, never settle any cases. And then as their leadership changed, the attitude about that within the organization changed. So organizationally, that's a thing that happens. I know that when COVID first started, there was the thought that plaintiffs might have a desire to settle their cases earlier on. That did not prove to be true. There were not a bunch of fire sales out there. People just kind of waited it out. So that definitely wasn't the case. But I do think that if we were already settling 99% of cases, then maybe now we'll settle 99.3% of cases. I do think that there'll be a slight uptick just because of the lack of availability of courtrooms and juries.
I think it was a good point, and I'm glad you touched on it. Actually, that's been my sense as well, listening to the narrative kind of across the country from plaintiff attorneys, is that there is a subsection of plaintiff attorneys who are basically saying, do not settle, because they've spent a lot of time in COVID talking and strategizing. And I think that's one thing the plaintiff's bar does better actually than the defense bar, is sharing information. And my sense from some of these plaintiff attorneys is they're ready to come out swinging out of COVID, and they're not settling anytime soon. So I think it was a good point that you brought up, that, the thought being that everybody's just going to settle might not necessarily be true. So you can't really go in with the case thinking, this is going to settle. We're not going to work this up properly, because we're going to find out really quick, and you're going to find out and you're going to wrong, and you're going to be paying a lot more when you can't settle a case.
Yeah. And that probably should never be your thinking, that I think the thing should always be, I'm going to prepare to resolve if there's a way to resolve, but I'm going to work the case up like it's going to a jury, because that improves your chances of getting a settlement that's favorable to your client. You never want to just sit on it for so many reasons. I do professional liability work. So I represent lawyers in legal malpractice cases. And so again, I will say there are so many reasons why you do not just sit on a case and do nothing. You do not want to become one of my clients in one of those cases. So yeah, don't ever assume that a case is going to resolve. That's not the proper way to handle a settlement negotiation.
Yeah, very true. Well, Kellie, I really enjoyed this conversation. I thought it was really good information to get out there to the listeners. If people want to talk to you more, if they have questions, if they want to get a hold of you, how do they go ahead and get a hold of you?
Oh, sure. I'm on email, and my husband will tell you she's on email all the time. So you can always email me. My email address is so long, but it's my first dot last name. It's KELLIE .Howard-Goudy, which is G like goodness, OUD as in dog, Y, at ceflawyers.com. That's Cow Edward Frank Lawyers.com. Really, really long email address, but you can always just look us up on the web, Collins Einhorn Farrell. Simple Google searches show you, where we are, and email, telephone calls. We're always available.
Excellent. And I can be found at swood@courtroomsciences.com. I can also be found on LinkedIn. This has been another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences, Inc. We'll see you next time.